Item number 3.
I am appearing on behalf of the petitioner, my lord. This matter relating to my lord, the petitioner get higher marks than others in the 2016 selection process. Their obvious plea is that Priyanka Noshkar is pending before the division.
Throw the names. You may be aware, Mr. You are
Priyanka Noshkar matter, my lord.
I don't remember now. No,
Priyanka Noshkar.
Well, 32,000 was cancelled.
Cancelled in 2016 selection process. Out of that, there are some trained candidate and there are some untrained candidate. Out of that 42,949
Does
candidates.
not tell me this issue is pending anywhere.
My humble submission is that, my lord, my understanding this issue is not pending. Because of that, why I say so? This is my preliminary submission. Why I say so? Because in Priyanka Noshkar matter, the primary issue was that in Priyanka Noshkar matter, whether interview and aptitude test was conducted or not, properly conducted as per rule or not. Although some issue is there that less meritorious candidate got it. But this matter, my lord, they will say the Priyanka Noshkar matter, and their second plea ought to be that panel expired, obvious. In this regard, my lord, and yesterday also they take similar plea. In this regard, very recent, 7 November 2024, the Supreme Court passed a judgment. My lord, kindly take this judgment regarding the expiry of the panel. And the second thing is that if they say Priyanka Noshkar matter is how in the most of the 2016 matter, in my matter also, they say because Priyanka Noshkar is pending. So that's why my lord, kindly keep this matter after Priyanka Noshkar. This was the Priyanka Noshkar matter. That is their several. But fact is that they published the list in pursuance of High Court order. From that order, that is also not a error-free list. From the erroneous list, which was published by the board as a list, not as a panel, because till date, they have not published the panel. And one of the appeal is still pending before the division bench. They don't want to publish the panel, the board. So that's why, because Honorable Justice Amrita Sinha passed an order to publish the panel or produce the panel rather before the court. But court they not even submit that panel till date 2016. Panel till date not submitted to the court, not published error-free panel anywhere. They published first some of the candidate names in the year 2021. Thereafter, in pursuance of court order in the year 2022, that too erroneous. And thereafter, in spite of High Court order, they're not published.
Same thing every day. I'm tired of hearing.
Yes, my lord. Kindly, my lord, tell them to produce the panel to the court.
Wait, Mr. Sami. You had participated in 2016 selection.
Yes.
Right?
Yes.
This was initiated on 26 September 2016.
Yes, my lord. The advertisement is annexed in my petition, page number 31.
Page 31.
And 30 is the exact page, that is type page of page number 31. 30 is the rule to get. Yes, rule is there. 39.
So you participated.
Yes.
Then result declared.
Yes.
You were not found eligible.
But they have not published the panel because that's why in that 2016 selection.
Any list
no, not at all. Not at all. At that point of time, what happened, my lord? At that point of time in the year 2017, the then board president conducted a press meet. And that press meet, he says, whosoever got appointment, one-to-one communication.
Request my learned friend to confine to his pleadings.
What? That's my submission. This is my submission. What happened, my lord, in the 2016 selection process already a CBI investigation going on till date.
Then
till date CBI investigation is going on.
Then
बोलते ना
now then
बोलते
2016
ना,
selection process
Yes.
you participate. Then how the
yes, how this case cropped up. So, my lord, in the
no list, no
no,
panel.
nothing.
Then
And they says one-to-one communication. Each and everyone who got appointment in the 2016
but the
selection process-
appointment was given.
yes, one-to-one
Hey, let me
communication.
understand.
Yes, madam.
No list, no,
No,
panel,
nothing.
but
No.
some persons were given appointment.
Yes.
This is your case.
Through email.
Through email or whatever mode.
Yes.
Then some of the candidates approached this court.
Yes.
That is the Priyanka Noshkar.
No.
Then
Priyanka Noshkar.
no. How this court is involved by some petitions?
Some of the petitioner with the publication of list is a Somen Nandi and Ramesh Malik matter.
They approached. They were
approached,
the
yes.
participants.
They
Then
was
what
the,
happened?
they was the participant in TET 2014. I just say that Ramesh Malik and Somen Nandi fact. In the Somen Nandi, because my lord wants to award the
I want to
actual
know the
fact.
background.
Yes. What is the background? In the Somen Nandi matter, he was the TET unsuccessful candidate. He says, similarly, circumstances candidate, 269 candidates, they are also TET fail. But they got appointment in the 2016 selection process. Somen Nandi made several RTI applications. But ultimate, Somen Nandi not get the answer. He went up to Supreme. He, after SPIO, thereafter First Appeal, thereafter State Information Commission, thereafter he approached to the High Court. And in that matter, when there is a direction to file the report, whether 269 candidates was state passed or not, first the coordinate bench passed this order and the board filed a report. From that report, it is revealed that out of 269 candidates, the board gave one additional marks to them. And for that reason, they passed it. That's why they got appointment. But out of 269, there are several candidates who got 68 as per their.
How
yes,
this is regarding.
And that's why in the year
one of the allegations, there are two separate issues.
Yes.
One, some candidates, state failed candidate were given appointment.
Yes.
You are not in that category.
I am
That way you are TET pass.
Yes.
Now, some of the candidates alleged there was manipulation or
that too, at that point of time, there is no such situation. Because of that, the biggest impediment is the rule itself. Why I say so? At that point of time, some of the petitioners, they filed the writ petition to publish the panel. At that juncture, because at that point of time, Article 12 authorities were, that is as per the rule, that ought to be the transparent. That's why rule does not permit the publish the panel. That's why they says, and I believe
he is not obliged to publish the panel.
Yes. And that's why they not publish the panel. Because he maintained the transparency. After that issue came up, this Somen Nandi and Ramesh Malik matter, CBI investigation
was directed.
Thereafter, my lord, several things came up. And in that matter, Ramesh Malik, Somen Nandi matter, there is a direction and one of the order.
And
that order is,
I understand.
Yes, this panel published in the year 2022. 28 November 2022. Kindly turn page number 51.
Page number
51. Yes. Malad, may I read?
That was also earlier placed before.
Yes,
this
yes.
is regarding
So,
TT14.
No, this is regarding selection process of 2016 and 2020. Not yet qualified M-panel candidate against 42,949. Yes, this 42,949 means 2016 selection process and 16,500 means
42,000. You are on one of them on this 42,000.
Yes. No, I am not one of them. I am the participant candidate.
Not this within 42,000.
Yes. 42,949. They are, according to them, they are more meritorious. That's why they empaneled. And immediately this publication, the 29th November, the very next day, they published that notification. Yesterday I placed it, that this is a erroneous list. But we will, because at that point of time, take 2022.
No, what is your prayer now? Yesterday
Yes.
I heard you.
Yes.
That there
My
was
prayer is that
hacking of the list,
yes,
all
yes.
these things. I directed, disclose it on affidavit. I
Yes,
want to
yes,
understand,
yes.
not
The
on this oral
situation.
submission.
Yes.
I want to understand what you actually want to say.
Yes.
You are
So
a
from this list in 2022 list, from 2022 list, kindly take note of this and kindly cognizance of it. From this 2018-2022 list, I got some of the candidates who are less meritorious than me, they got appointment. Even after, because this, according to them, this is not an error-free list. But till that, today is the 2024, the flag end of the 2024. Kindly direct them to produce the error-free panel to this court.
No, error-free. You are alleging error-free.
No, 28 November, that
They
is
have
their
notification. They have said that they will justify their
Yes,
notification.
they have to be.
They have to justify their notification. But can you? Why this 2016? Everything was done. So
Yes.
it was.
Yes, because at
Why
that point of time,
Why you are coming? Why you are coming now?
my lord, kindly see page number 56 onward. My lord, kindly take page number 56. Without this Dipannita Samanto, because this is out of 50, the selection process is 50. And out of 50 Dipannita Samanto, without Viva marks, without aptitude marks, my marks is 13.746.
This is TET.
No, my lord. Selection process. My lord, kindly, before that, my lord, kindly take the rule.
What means MP means?
MP means Madhyamik Pariksha. My lord, before that, it will be for giving the clear picture, my lord. Kindly take the rule. My lord, kindly take page number 39, the rule. Start from page number 39. This is the rule. By dint of this rule, they conduct this selection process. Kindly turn page number 43. This is the chart, the marks allocation, page number 43. What is it?
Yes, that is it.
Yes, madam. Kindly,
will be allotted
yes,
according to
in Madhyamik 5, higher secondary 10, training as specified by NCT 15, teacher.
Very well. Well, this is allocation of marks.
Allocation. According to that allocation of marks,
You have got this. There cannot be anything else because your marks have been assessed. Are you
no, my marks is assessed without aptitude test and
very well? But your marks is assessed without aptitude test.
Viva test, and that too
What do you
13.746.
want?
My lord, kindly turn page number 57. Very next page.
Page
57, very next page. My lord, see, there are lots of candidates less than me with Viva Bhose and TET marks. Viva Bhose and interview.
Show me one.
Kindly take Prashanto Satra.
Prashanto Satra.
Yes.
Number 1.
Yes, my lord. His marks TET scored 3.2. His Madhyamik marks 3.
Total score is 12.6.
12.6, which is higher, 12.6.
No.
So my marks is higher.
Can you suggest this is a general category candidate?
Yes, I am a general category candidate also.
Is there any other specification? That
Yes, yes.
Score.
Yes.
Why are you going here and there? Straightway come. You are a participant in 2016 selection process.
Yes.
This is the list of 2016 published in terms of the order of the court.
Court. In
Now,
the year
the
20.
number 1, this total score is 12.673.
Your
Score is 13.74 without Viva.
Without Viva and without aptitude test.
How can be reconciled with? This is they will disclose.
Yes.
They will disclose by in a form of a report or an affidavit.
There are several candidates.
I think my connection is
Obviously, after your submission, I will give answer. Obviously.
The read petition. I will confine to the. Now your losses will find He's an untrained candidate. He's an untrained candidate.
This is the first hurdle.
First, then your losses. I will take your losses. 3-4 paragraphs, only 3 lines. Kindly take paragraph 5. Page 4, continuation. The continuation, page 4, first 2 lines. The petitioner qualified in the teacher eligibility test 2014 conducted by the board.
Paragraph 5.
Paragraph 5, continuation.
The petitioner was satisfied with regard to the performance.
No, your losses. Yes, then your losses. State qualified.
Volunteer.
Before that, paragraph 4, admittedly untrained candidate. Paragraph 7, your losses. Kindly skip over the first 6 lines. Thereafter, the petitioner being general candidate was called for scrutiny verification, interview, aptitude test. The petitioner was attended the scrutiny, all that. The petitioner was not selected or empaneled in the post of assistant teacher pursuant to the advertisement. So, in 2016-17, he came to know that he was not selected. Then your losses, kindly consider paragraph 8. He says the board never disclosed the marks obtained by the petitioner. An unsuccessful marks, the candidate's marks never disclosed in any selection process. Then your losses in the same paragraph, your losses will find there is after 4 lines, the respondent board also never disclosed the panel with marks. That means I disclose the panel without marks. There are panel prepared with losses with the marks without disclosing the marks. Now your losses, kindly see paragraph 9. On television news channel on 31st January 2017, your petitioner came to know that the concerned respondents authorities has conducted a press conference, wherein the concerned respondents has declared that TET qualified candidates would be appointed as primary teachers, and SMS email will be sent to them for appearing for the council. My contention is that he came to know in the January 2017 this fact, all these facts. Then your losses, paragraph 10. The petitioner is a qualified candidate, but surprisingly, the petitioner has not received any SMS. He came to know 2017. Then your losses, paragraph 13. After a long period, as per direction of the Honorable Court, the respondent board on 11 November to compel to publish the marks candidate. Now, what is the how he is agreed? He didn't feel agreed. From 2017 to 2022, even today, he felt aggrieved when this was published. This is an individual.
Before that, what was his occasion to know about the breakup of marks?
Well, he could have applied for. There are this open right to
Mr. Sanda, a candidate.
Kindly take.
Wait. A candidate appeared in examination with full trust on the board. He has been declared an unsuccessful candidate. He sat tight. He did not do anything. All on a sudden, somehow, somewhere, a court case involved. Ultimately, under the pressure of the court, the board disclosed the breakup of marks and everything. Then the candidate came to learn that, yes, I got passed, but I was declared. Is it the date when the starting point of limitation start? Limitation always has two ends. Starting point.
It's of limitation. I'm not.
I'm
not at all on limitation, man.
He was sat tight over his right for a long time. Now, what was his cause of action? How he felt aggrieved. A person felt aggrieved when he came to learn about his or her deprivation. When he came to learn in 2022 or 2023, then he promptly reacted. What I require,
he has not prompted.
Very well, you take this point of yours, but kindly reconcile with is there, because is maybe a situation, even today, I would like to give benefit of doubt to the board that a person who scored 13.74, he did not been accommodated, but a person scored 12.673 has been accommodated unless there is some special feature for that person. Supposing he belongs to a reserve category, he has been so many classifications may be there. And the other way around, whether this issue has already been settled anywhere, where it is under consideration in anywhere, whether this has got any relationship with the ongoing investigation by the CBI. If three things are there, for the time being, this court may not go into the merit of this matter. Kindly apprise this in the form of a report
Yes.
before me, so that I can get a black and white picture of the
Well,
situation.
may I make humble submissions here? As soon as your lordships call for a report, it amounts to entertainability of the report.
Of course,
My very first, my lord,
very well,
submission is
very
that-
well. Very well. Would you like to keep it open, or I would like to overrule this objection here and now? Please, Mr. Sannal, I'll keep it open. It is not a final decision, but my conscience must be clear. A candidate on papers is showing he has scored 13.746, and your panel shows, or whatever the breakup of marks under whatever circumstances.
I think, my lord, with these sort of allegations, he is not coming up first. Your lordships has dealt with this already.
Yes, always, always, always.
And this is meritorious candidate was not.
No, meritorious. Let me have.
See, with this, my lord, there must be an end to a process. It can't go on. You know, see paragraph 3, the third paragraph.
But
All the honorable judges, my lord, has not entertained this. Then this will not be a process, your lordship, in the selection
This
process.
life has now he said this is a situation when maybe he could not demonstrate, but last occasion he showed your notification that your notification says that this
Erroneous.
panel is, or whatever name you may call this panel, is erroneous. Somebody hacked the site. Therefore,
That was a 2020 recruitment process.
My lord,
Malad,
very
there are after 16, malad, 3 recruitment process.
Mr. Sannal, assist me again like that matter
yes.
to pin down it with sufficient reason.
Yes.
Not
Malad, my humble request your lordships to that, whatever your lordships go, malad, the court should not at this stage after 8 to 10 years go into
yes.
the illegality.
I want that you should specify it in your report in whatever form, so that it can be dealt with forever.
Malad, I can demonstrate your lordships only on the point of entertainment. That
So
this
far,
should
this,
Malad,
are you
that's my
accepting
point, your
this?
lordship.
Are you accepting this?
Which one? Malad, this is not question of acceptance. Your lordship should not go into it.
Very well.
I know.
I understand your
not
point.
go into it.
That since that's done, please file a report
Yes.
specifying the allegation and entertainability of the repetition, both, so that
But
it
I
can
do
be.
not go into the specific the
Yeah,
allegations.
yes.
That's my point.
It is you to decide. You to decide which point you will be dealing with. It is you to decide. But if you are stick around, then stick around it. Convince me that this court cannot go into that, even if it is staring at my face, whatever the situation, whatever the court, and if you can demonstrate it is really the panel has already attained finality, there is no scope of reopening it.
Admittedly, panel has 2018.
My lord,
Please,
finally.
I want to
Very
bring
recent 5 judges benches judgment. I want to cite it. Just 3 lines, nothing else. And I get the citation. And very recent judgment, that is 2024 INSC 847 regarding Rajasthan High Court recruitment.
which paragraph should
Now
I
the
read?
conclusion, para 4. Conclusion portion, para 42, sub-para 4. I just read it. Recruiting bodies subject to the extent rule may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. What is the object of a public employment? That is a meritorious candidate got appointed.
Supply him a copy or
Yes, my lord, this is that judgment, very recent 5 judges judgment, 2024 INSC.
And
is
Mr.
the date
Sami,
of the-
practically you people are filing heaps of these matters.
Because of that,
Now,
why I uplifted my lord, why big at that
Kindly
point.
allow the court to come
Sorry,
to a
sorry.
definite conclusion and a definite matter.
Sorry, madam.
The defense is that after 2016, long time has elapsed. This issue cannot be reopened. Secondly, if the panel is actually expired,
Yes.
And in some of the cases, Supreme Court judgment has already 2020 selection process. It cannot be reopened. Whatever comes, whatever the shocking things you may bring to the notice of the court.
No.
If you, yes, that judgment is.
But this is subsequent is a 5 judges bench judgment. That's why I
No,
say
this is
party.
not the point.
My
Not every
if-
judgment should not be cited. What says there should not be arbitrary? The
The,
question is after expiry of the panel.
yeah,
court should
I
entertain.
am not on this point. I am on my conscience. I'm telling you, when you are demonstrating something, let me hear Mr.
Yes, yes.
Sannal with a report, not any verbal
Yes,
submission
yes,
anymore.
I'm extremely grateful.
The petitioner had participated in the selection process initiated by the West Bengal Board of Primary Education.
But may I take a losses, leave my
No, wait. One thing is necessary for you. Recruitment process. Now, one caution. You cannot appear alone in any matter before me.
I'm not happy.
This is a caution to you. Dekho. Yes, you may leave now. For recruitment of assistant teacher in primary schools, petitioner had participated in the state selection process, but was unsuccessful. Long time thereafter, the breakup of marks secured by the candidates, participant candidates of the said selection test were published by the board. Mr. Samim, you hear it?
Yes, ma'am.
Fact recording.
Yes, ma'am.
Wherefrom the petitioner is alleging he or she
She,
came to learn that less meritorious candidates have been accommodated. They are accommodated. Stop. The petitioner is now praying appointment, treating him as a successful candidate in the state selection test. Mr. Sannal, under senior advocate for the board, vehemently submits that this petition is not maintainable, as it appears from the pleadings that the petitioner was aware of the result but remained inactive over her alleged right. Stop. The document annexed to the writ petition, particularly the merit list of the said selection test and the marks allocated to the petitioner without what is called
Without Bhaiba Bose and
Viva
aptitude
Voce
test.
and
Aptitude test.
aptitude test is higher than some of the selected candidates. Stop. The petitioner petitioner, as it appears from the pleadings, was aware that she was not successful in the selection test, but from the pleadings, it cannot be inferred that she was aware of the marks she secured. Therefore, prima facie, the cause of action of the writ petition is on the date of her acquiring knowledge of the breakup of marks of her breakup marks vis-a-vis the marks of the successful candidates. However, the issue regarding maintainability of the writ petition as urged by Mr. Sharma is kept open. The board is directed to file a report in the form of affidavit on the next date of hearing. Matter be listed in the monthly combined list of December 2024 under the heading motion.
Malat affidavit of service malat kept on.
Affidavit such document.
Although
Judgment of
both the parties appeared. The very next matter is a similar, malat affidavit of service and deficit court fees malat kept on.
I place it in the monthly list December because I want to concentrate in one matter first.
Malat two matters, kindly these two.
These two matters. Affidavit of
Because of that point of time, there are district-wise appointment. And district-wise, this is regarding Purba Mendipur, this is regarding Malda.
which one?
The very next one, the exact affidavit of service and deputy.
No, first one is
Purba Mendipur.
Purva Mendipur.
Yes, Malat. And this
The initiation of the selection test
by the board, by the board. But the panel says, suppose district-wise panel they ought to publish. Thereafter, category-wise. Thereafter,
Whatever, don't more
so
complicate.
that's why in this page, Malat kindly
Let it
take.
be placed. Let it be placed in the monthly list.
Yes. Malat kindly.
Affidavit of service and the
Malat until and unless report, Malat similar order, Malat kindly. I prayed for
let you
Malat until and unless suppose Malat.
let you cross the hurdle of the first one,
But-
maintainability and other thing. Let me decide that point. If in the similar
Malat
matters
kindly
will
take
follow
it.
the
These
same
two
row,
matter. Nothing. There's two matter. Malat
it will take the same row.
I count the all the judgment, this point already decided.
Take this in your report.
Yes.
Unnecessary exercise. I will
Malat kindly
Uh,
take up this Malat
the-
this matter also.
acknowledgement, evidencing payment of deficit court fees and the affidavit of service filed on behalf of the petitioner be kept with the report. Place the matter in the supplementary in the monthly combined list of December 2024. As other similar matters have been so directed.
As Malat been extremely grateful.